Hello everyone, welcome back to part 2 of what constitutes the employment law. I hope you find the part 1 helpful, so let's see the other sources of employment law. In part 1, we talked about the common law. Now, let's talk about the biggest and most direct source of employment law in the UK, which is statute law in employment. What is statute law? It's basically all the laws that Parliament create to set out your rights and duties at work. There are two main types. First one, primary legislation. These are the Act of Parliament, the big official laws. Second one is secondary legislation. These are extra rules called statutory instruments that fill in the details and make the law work in practice. So, if common law is the invisible framework, statute law is the rule book written in ink, clear, specific, and binding. Key examples you should know are first one, Employment Rights Act 1996. This is like the Swiss Army knife of employment law. It covers contracts, redundancies, notice period, and what counts as fair or unfair dismissal. Second one, Equality Act 2010. This one says no to discrimination at work, whether it's about gender, race, disability, age, religion, or other protected characteristics. Third one is Health and Safety at Work Act 1974, which keeps you safe by requiring employers to protect your physical and mental well being at work. Fourth one, National Minimum Wage Act 1998, which sets as the lowest amount you can legally be paid per hour. Finally, the fifth one is Trade Union and Labor Relations Act 1992, which covers trade unions, industrial actions, and how employers and employees negotiate together. Why it matters is statute law is the most direct and wide ranging source of employment law. It leaves very little to guesswork. It's written down, published, and applies to every workplace in the UK. If you work in HR or you are an employee or employer, these laws aren't optional reading. They are the bedrock of how work is supposed to happen in the UK. Now let's talk about a part of employment law that keeps it alive and up to date. Employment tribunals and higher court rulings. What's their role? Employment tribunals and courts aren't just there to decide who's right and wrong in one case. Their decision actually set precedents that means the way they interpret the law in one case becomes a guide for how similar cases are judged in the future. Think of them like referees in football. They don't change the rules, but their calls can affect how those rules are understood for years to come. Why are they so important? Even though we have written laws, not every real life situation fits perfectly into the wording of those laws. Tribunals and courts step in to fill the gaps, clarify grey areas, and sometimes even challenge how the laws are applied. Some of the real life examples you should know are Auto Cleanse versus Belcher 2011. This case looked at whether workers were truly self employed or actual workers. The court said just because a contract calls you self employed does not mean you are. What matters is the reality of working relationship. Second one is Forstater versus CGD Europe 2021. This case confirmed that gender critical beliefs are protected under the Equality Act. It expanded understanding of what counts as a protected philosophical belief. Third one, Pimlico Plumbers versus Smith 2018. This one was huge for the gig economy. It confirmed that someone who looks self employed on paper can still be legally considered a worker with certain rights. I will be attaching the link for each cases mentioned above in the description so that you can go read and understand. These rulings just don't stay in the courtroom. They shape workplace policies, contracts, and how disputes are resolved. If you work in HR, you can't just know the law. you need to know how the law has been interpreted in recent cases. In the part 2, we have learned statute law gives us the rules, where tribunals and courts tell us exactly how those rules plays out in the real world. So, we have covered common law, statute law, and tribunal rulings, but those aren't the only sources of employment law. We also have assimilated EU law, soft law, and code of practices and international and human right law. If you would like me to break down these in detail in another video, make sure you drop a comment below saying yes. Your feedback will be decided what we cover next. If you find this video informative, please go ahead and hit the subscribe button, give this video a thumbs up, and thank you so much for watching.